This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. The Ohio Revised Code defines public records as records kept by a public office. The terms records, kept by, and public office have specific legal definitions that we will discuss in this presentation. To meet the definition of a record, a particular item must meet all three prongs under the following test. To be a record, information must be stored on a fixed medium, created, received by, or come under the jurisdiction of a public office, and documented to explain the organization, functions, policies, decisions, procedures, operations, or other activities of the office. We will now review each of these elements in some detail. The first prong of this test requires that information must be kept on a fixed medium to be a record. This can include CDs, Excel spreadsheets, or any other form of storage. As long as the information is stored in some way that it can be later recovered, this first requirement is met. This slide displays examples of items on which information can be stored, including cassette tapes, emails, and pictures. However, if information is not stored on a fixed medium, this information would not be considered a record, but would instead be considered a non-record. For example, a conversation between two people that is not recorded or documented in some way does not satisfy this first requirement because there is no recording of this conversation. As another example, if a public office receives a public records request for a list of all cases that the public office is handling, and the public office does not maintain such a list, the requested list is not in existence, and as a result, there is no record that is responsive to the request. A public office has no duty to create such a list if one does not exist at the time the request is made. The second prong of this test requires that the record must be created by, received by, or come under the jurisdiction of a public office. While it may be easy to determine whether items are created or received by a public office, it may be more difficult to determine whether a particular item comes under the jurisdiction of a public office, because it may be held by another entity that is performing a public function for a public office. This concept will be explained in greater detail during our discussion of the definition of public office. Finally, the third prong of this test requires that the record document the organization, functions, policies, decisions, procedures, operations, or other activities of the public office. Under this prong, it is necessary to look at the content of the record rather than at the location or format that it is kept in to determine whether a particular item is a record. While some may assume that all paper and digital items in the possession of a public office document what the public office does, that may not necessarily be the case. For example, are spam emails that employees of a public office receive and never solicit, never respond to, or never use records? Let's analyze whether spam emails meet the definition of a record under the three-prong test. In looking at the first prong, spam emails are stored on a fixed medium, an email, so the first prong is satisfied. The question under the second prong is whether an email containing spam sent to employees of a public office was created by, received by, or comes under the jurisdiction of a public office. Again, the answer to this question is yes, because the spam email was received by employees of a public office. Finally, under the third prong, the question is whether spam emails document the activities of a public office, whether the public office actually uses the spam email to carry out its duties or responsibilities. In this particular example, the answer is no, because the employees never requested the information contained in the spam email. They never used the content of the spam email to carry out their responsibilities, and the content of the spam email does not document anything that the public office does. As a result, the third prong of this test is not met. Because the spam email does not meet all three prongs, the spam email is a non-record of the office. If, however, the employees of the public office actually used the information contained in the spam email to, for example, accept the email's offer to buy office supplies, then the public office has transformed that email from a non-record into a record by using the contents of the email to carry out their responsibilities as employees of the public office. Keep in mind that it is important to evaluate an item based on its content, the type of information contained in that record, as opposed to the location or format in which information is stored. We will now move on to discussing the second part of the definition of a public record, which is a record kept by a public office. A record is a public record only if it is kept by a public office. That means that at the time the request is made, a record must actually be in the possession or control of the public office under the terms of its records retention schedule for such records. Records that are not yet in existence or which are in existence but have not been received or come under the control of the public office are not public records. At the end of the period that a public office keeps a record, it disposes of it pursuant to the appropriate records retention schedule. When a record is properly disposed of under the records retention schedule, it is no longer being kept and is therefore no longer a public record subject to the Public Records Act. Finally, to be a public record, the record must be kept by a public office. A public office is everything we typically think of as the government and includes any state agency, political subdivision, or other organized body, office, agency, institution, or entity established by the laws of this state for the exercise of any function of government. Sometimes records held by private entities may also fall under the jurisdiction of a public office. Specifically, courts have extended the definition of a public office to include private entities that are the functional equivalent of a public office. Under this test, courts consider 4 factors: whether the private entity performs a government function, the level of government funding, the extent of government involvement or regulation, and whether the entity was created by the government or to avoid the requirements of the Public Records Act. Courts weigh these factors to determine if there is clear and convincing evidence that a private entity is the functional equivalent of a public office that is subject to the Public Records Act. In addition, when a public office contracts with a private entity to perform government work, the resulting records may be public records. Courts analyze 3 factors to determine whether records held by a private entity that contracts with the government to perform government work are public records, including whether the private entity prepared the records to perform responsibilities normally belonging to the public office, whether the public office is able to monitor the private entity's performance, and whether the public office may access the records itself. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback.